I read this is the board will just change the words on the page. It won't really, it doesn't open up a new procedure. It's merely a textual change. So, I don't think just paying the lawyers will make a very unfair procedure fair. Obviously lawyers like getting paid. That's our job. But the underlying procedure is unfair and there's already a solution in place, and nobody's really explained what's wrong with the solution. In fact, there's lots of benefits because 95% of planning decisions where the decision is quashed goes back to the board to make a new decision. But they have the procedural flexibility to deal with it properly, and it's not just a mere textual change. And people won't trust, the people will not believe that there was just a mistake in typing up the decision. I guarantee you. And what will happen is board members will have to give evidence. They will have to swear affidavits about what happened. They'll have to be called to give oral evidence. Inspectors will have to give evidence. It's not even clear whether the inspector's report can be amended, because that forms part of the decision. I don't see a clear, bright line between fact and law, because these are mixed. This is applications of the law to the facts. So you can't say, except in maybe very particular situations which aren't dealt with in the draft, that there can be a clear distinction between fact and law. And then on section 50B, or the cost provisions, I know Oireachtas will talk about it, but from a legal point of view, on the 10th of November 2022, we got legal certainty from a judgment called Heather Hill. There have been huge amounts of litigation. The whole planning judicial reviews were being held up because of this issue. We finally got legal certainty where it's not an issue anymore, there's no disputes over it. And then literally 2 months later, it's been decided to throw it in the bin, for want of a better word, and replace it with something that nobody can actually explain how it works or how it's going to work. And the issue is, why abandon something that's through 13 years of litigation has reached some kind of stability, and go back in time 10 or 15 years and start that process all over again, and end up in the same place. So what I think should happen is that we should keep what we have and build on it, rather than abandon what we've got to at this stage for want of something new. It's like if you had a leaky tap and you basically decide to demolish your house because you have a leaky tap. You fix what's broken, you don't throw away what actually works or what actually has been proven to work.